Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Late last night, Justin Baldoni and the Wayfarer parties filed an opposition to Leslie Sloane, who's asking the judge to have Wayfarer pay her attorney's fees and costs. I'm sorry if you hear the lawn people in the background, but I can't do anything about that, so... Leslie Sloane and Vision PR invoke New York's Anti-SLAPP statute, New York Civil Rights Law Section 70A, and the court's inherent power to award attorney's fees allegedly expended to defend now dismissed defamation claims brought by the Wayfarer parties. There are a myriad of reasons why Sloane's motion should be denied. First, a motion after a Rule 12b6 dismissal is not the proper procedure to seek fees under Section 70A. On its face, Section 70A applies only to an action, claim, cross-claim, or counterclaim. The overwhelming majority of courts in this district interpret this language as requiring parties seeking anti-SLAPP damages must bring an affirmative claim for relief under Section 70A, not proceed by a motion after dismissal. Sloane did not bring a counterclaim for relief under New York's anti-SLAPP statute. Second, the majority of Second Circuit and district courts hold that the state anti-SLAPP motions do not apply in federal actions. Finally, Sloane falls back on the court's inherent power as a basis for fee shifting. Sloane, however, has not met her burden to show the egregious conduct, including bad faith, necessary to warrant sanctions under the court's inherent power. A dismissal rule under 12b6 for failure to plausibly plead a claim does not equate to the egregious bad faith conduct warranting sanctions under the court's inherent power. For these reasons, as elaborated below, Sloane's motion should be denied. So I am going to skim over a lot of this stuff, but I'll put a link to the document down below. This dispute arises from allegations by Blake Lively that she was sexually harassed by Justin Baldoni and others on the set of the film It Ends With Us. Plaintiff's first amended complaint alleged that in the summer of 2024, Vision PR and its principal Leslie Sloane worked with Lively to spread false and defamatory allegations about Baldoni and other Wayfarer parties to the press, including the New York Times, as part of Lively's scheme to wrest control of the film from Baldoni, its star and director. The scheme to develop a false narrative through the news article and video scheme unfurled, culminating in Lively's filing of complaint with the CCRD. On June 9th, the court granted Sloane's Rule 12b6 motion to dismiss their defamation claims against her, finding that the Wayfarer parties had failed to plausibly plead their defamation claim, or that Sloane did any more than repeat Lively's version of events, which she had no reason to doubt, and California's fair reporting privilege would have applied to the extent the claims involved the disclosure of Lively's CRD complaint to the New York Times. As part of her motion to dismiss, Sloane requested an award of fees and costs. The court denied the request for fees without prejudice to a future request under Section 70A. Sloane cannot recover fees because she has not filed an affirmative pleading as required by Section 70A. A claim for attorney's fees and costs pursuant to Section 70A must be brought not by way of a motion, but as an action, claim, cross-claim, or counterclaim for damages under Section 70A. Sloane's motion ignores the statutory pleading requirement necessary to recover fees under Section 70A and assumes that a motion is sufficient vehicle to seek costs and fees. Sloane overlooks the key reason why this relief must be requested through a pleading. A separate pleading is required because a party seeking relief under Section 70A must assert factual allegations from which the court can plausibly infer that the plaintiff has violated New York's anti-SLAPP law by bringing a defamation claim that lacks a substantial basis in fact and law. In sum, because the amended complaint was dismissed before Sloane asserted any affirmative claim, per the terms of the New York law, Sloane must file a separate lawsuit in order to recover any attorney's fees. State anti-SLAPP laws do not apply in federal courts. In deciding Sloane's motion to dismiss, the court applied California law. So here they're going to argue that California law applies, not New York law, but either way, they don't think the state statute should apply in federal court. This is a lot of the stuff I'm going to skim over, but like I said, I will put the link to the full thing down below for you if you want it. They mention here that Sloane has not met her burden to show that the claims against her lacked a substantial basis in fact or law. Sloane's request for inherent power sanctions should be denied. The court has the inherent power to impose sanctions for bad faith conduct. The court's inherent powers do not extend to awarding attorney's fees to make a prevailing party whole. Further, Sloane's notice of motion makes no mention of any request to impose sanctions. As a general matter in the United States, the prevailing litigant is ordinarily not entitled to collect a reasonable attorney's fee from the loser. There are exceptions, and federal courts are vested with the power to sanction an attorney or party pursuant to their inherent power to manage their own affairs. This power includes the ability to fashion an appropriate sanction for conduct which abuses the judicial process, such as the assessment of attorney's fees against a party that has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. Importantly, however, because of their very potency, inherent powers must be exercised with restraint and discretion. A district court may appropriately exercise these powers when, for example, a party practices a fraud upon the court, or delays or disrupts the litigation, or hampers a court order's enforcement. Courts use their inherent powers sparingly and only in the most egregious circumstances, where the moving party shows by clear and convincing evidence that the party to be sanctioned acted fraudulently or in bad faith by bringing a frivolous claim for no proper purpose. In the Second Circuit, before a district court can impose sanctions using its inherent powers, it must make two findings. One, that the challenge claim was without a colorable basis, and two, that the claim was brought in bad faith. A claim is without a colorable basis when it lacks any legal or factual basis. As for the latter, bad faith may be inferred when an action is so completely without merit as to require the conclusion that it must have been undertaken for some improper purpose. Both findings must be supported by a high degree of specificity in the factual findings. Further, bad faith must be shown by clear and convincing evidence. Neither element is met here, much less with the requisite specificity or evidentiary support. The court has made no such determination, but found only that the Wayfarer parties failed to state a claim under Rule 12b-6. The Wayfarer parties' defamation claim against Sloane was twofold. First, that Lively, Sloane, and Reynolds worked together to spread a false narrative about them to the New York Times, to the effect that they engaged in sexually inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruin her reputation. And second, that Sloane individually made false statements to other press outlets that Baldoni had committed sexual misconduct. The court did not dismiss these claims because they were without a colorable basis, but because the Wayfarer parties failed to adequately plead Sloane's involvement in Lively's provision of the draft CRD complaint to the New York Times, or that Sloane individually, in making statements to a Daily Mail reporter, that'd be James Vituska, that Baldoni sexually assaulted Lively, did any more than repeat Lively's version of events, which she had no reason to doubt. As to the former, the court found that Sloane's participation, if any, would have been protected by the fair report privilege. Sloane points to a declaration submitted by the Daily Mail reporter disavowing that Sloane had made such a statement. The reporter James Vituska had previously stated exactly the opposite. In the messages, Vituska was explaining how, during the summer of 2024, Sloane had been telling him that there were issues on set because everybody hates Justin, but had not asserted or even insinuated that Baldoni had engaged in sexual misconduct towards Lively. Indeed, Sloane had specifically told him that the tensions on set, had nothing to do with Blake. Sure. By contrast, after the publication of the Times article, Vituska noted that Sloane is now saying that Blake was sexually assaulted. Vituska noted the sharp discrepancy in Sloane's story and wondered aloud why she would not have said anything back then. Vituska's recent disavowal of his prior statements is not credible. Vituska now claims that he meant to say sexually harassed and was referring to the allegations in Lively's CRD complaint and not in reference to any conversation I had with Leslie Sloane. Whatever he meant to say, his statements were not ambiguous and his explanation does not make sense, and at the time their complaint was filed, the Wayfarer parties had every right to rely on the statement. They were not required to have a crystal ball to predict that Vituska would change his story. Therefore, the inclusion of Vituska's statements in the amended complaint was neither knowingly false nor a function of any failure of diligence on the part of the Wayfarer parties. The reason for the claim's failure was instead a failure to adequately plead the requisite state of fault. The Wayfarer parties' failure to meet the high bar of establishing actual malice is not evidence that their claim lacked a colorable basis. Indeed, there is significant circumstantial evidence that Sloane did know Lively's allegations of sexual misconduct were untrue, given her failure to mention them when disparaging Baldoni to reporters in the summer of 2024. Nor is there any evidence that the Wayfarer parties asserted their defamation claims in bad faith. Sloane argues that the Wayfarer parties sued her to distract from their own misconduct and silence Miss Sloane, okay, and that their lawsuit was a mere publicity stunt. Sloane, of course, offers no support for these theories. The Wayfarer parties filed suit in the aftermath of a coordinated hit orchestrated by Sloane in concert with Lively, Reynolds, and the New York Times. The individual Wayfarer parties watched as their reputations, careers, and future prospects disintegrated into dust, and as the viability of their studio. I don't know if that was supposed to be the end of that sentence, but we'll let it go. Most importantly, the Wayfarer party's abrupt reputational, social, and economic collapse was premised on a series of accusations that the Wayfarer parties will show as false at trial in the Lively action. Indeed, the falsity or Lively's claims is the Wayfarer party's core defense, and nothing in the court's order dismissing the Wayfarer party's defamation claim impairs that defense. I had some people send me DMs last night about this line here, how they're going to show this as false in the Lively action, asking about whether that means they're not going to appeal. I'm not a lawyer, so I really couldn't tell you for sure. I don't understand that to mean that, but, maybe they won't. I couldn't tell you. But I understand this line to mean exactly what it says, which is just that they're going to show this was false at trial in the lively action. So I don't know. I don't know, man. The Wayfarer parties are aware of no authority supporting the imposition of inherent power sanctions against a litigant or his counsel as a consequence of failing to state a claim. Where such sanctions have been issued and upheld, the conduct at issue invariably involves an element of bad faith that is missing in this case. Absent a finding of bad faith, there's no basis for imposing inherent power sanctions. In short, Sloane's request for sanctions pursuant to the court's inherent power should be denied. All right, guys, that's all I got for this one. I have to get back to work and I have to travel later today. So thanks for watching, and leave me a comment down below letting me know what you think. I will see you all soon.